Good morning, everyone. We might get started. So, thank you all for joining us for today's webinar. Happy New Year to everyone as well. Our first webinar back. We are recording this session, and we will send out a link to all the members in the coming days. So, if you do miss part of it or you are joining us online, we will send that out afterwards. My name's Summer. I'm the Projects and Events Manager for MPAQ, and today I'm just moderating. And today we will be talking about the critical topic of wage criminalisation and the legal implications of intentional wage underpayments, which commenced on the 1st of January 2025. We're joined by Clinton. He's our Senior Workplace Relations Consultant, and he's going to help us navigate this evolving legislation. Clinton, thank you for joining us.
Thank you, Summer. Morning, everyone. Happy Thursday. I hope everyone's been having a good week. Just a bit of background about myself. So yes, I'm a workplace relations consultant with MPAQ. I may have spoken with you. I may have sent you an email. Hopefully it was good, but thank you for joining this morning. So what I'm going to do today, and by all means, like, this is a very hot topic now, given that it's now been in force since the 1st of January. If you do have questions, feel free to definitely ask me. I would just say maybe save the questions towards the end, just so we can be able to go through a lot of the material. But yes, it's a very interesting time, given wage theft used to be a state-based legislation, but now it's being implemented federally. So there's a lot to take away from it. But yeah, let's get started. Any questions at this stage, or? Great. So let's just move forward. So yeah, so look, in terms of an agenda, we're going to go through the legislative landscape, what obligations should be employers should be mindful of in terms of just the incoming legislation, in effect legislation, and steps of risk mitigating. So in terms of wage theft, simple question, well, what is it? As I was saying before, individual states such as Victoria and Queensland have had wage theft offenses before. Now that it's a federal offense under the Fair Work legislation, rather than just being state-based, the Fair Work legislation amendment Closing Loopholes Act 2023 introduced an offense for wage theft through the new section 327A of the Fair Work Act. As I said before, the new offense took effect from the 1st of January 2025. Funnily enough, wage theft, the term is not defined. Rather, Section 327A, subsection 1, provides that an employer commits an offense if the employer is required to pay a required amount to or on behalf of or for the benefit of an employee under the Fair Work Act, Fair Work Instrument, or a transitional instrument, and the required amount is not an amount covered by Section 327A, subsection 2, and the employer engages in conduct, and the conduct results in failure to pay the required amount to the employee in full on or before the day when the required amount is due for payment. So there's a lot going on there, but today we'll break that down, and hopefully it'll be better in terms of layman's terms or in a general sense. Yeah, so if you were listening to what I just kind of said verbatim, engage in conduct. So interestingly enough, that term is defined in Section 12 of the Fair Work Act. Specifically, it means engage in conduct to do an act or to omit to perform an act. So now, in terms of how wage theft is demonstrated, I've just provided a bit of an overview on the screen, but what I'll do is I'll just go through that a little bit more in detail. So an employer will commit wage theft in circumstances where they intentionally engage in conduct that results in the failure to pay an employee their minimum statutory entitlements arising from the Fair Work Act or an industrial instrument such as the Modern Award or Enterprise Agreement. So unintentional failure to pay employees their required amounts will not be considered wage theft. So the wage theft provisions will be incorporated into the Commonwealth Criminal Code, or the CC Code for short. So how do you actually demonstrate that? So in terms of standard of proof, so given the seriousness of a finding that wage theft has occurred, for a prosecution of a wage theft offense to be successful, fault must be proven to the requisite criminal standard, which is beyond reasonable doubt. This means that it must be proved that the employer intended to engage in such conduct, knowing it would result in not paying the employee their full statutory entitlements. So essentially, for there to be an offense, the person must mean to bring about the result, that is, a failure to pay the required amount, or be aware that the result will occur in the ordinary course of events. So underpayments that are accidental, inadvertent, or based on a genuine mistake are not intended to be caught by that provision. So let's go through an example. So if an employer genuinely misclassifies an employee and pays them an hourly rate of $25 per hour instead of $30 per hour, as required under the correct classification in the award, the resulting failure to pay the required amount would not be regarded as intentional and should not be caught. By way of further example, this may include obligations such as payment of annual leave under the Fair Work Act, industry-specific redundancy payments, and travel allowances under the Plumber's Award, or circumstances where an employer withholds money from an employee to force them to give something back. So I recommend that you contact our advice line to discuss employee entitlements and final pay, especially in situations in which an employee is to be terminated, to determine aspects of payment, such as the industry-specific redundancy scheme. However, it does not extend to entitlements that arise solely under the terms of a contract. For example, if you provided in your contract that you're paying full-time employees 6 weeks of annual leave as opposed to the mandated 4 weeks of annual leave, superannuation contributions, payments for taking long service leave, payments for leave associated with being a victim of a crime, or payments for leave taken for jury duty or emergency service activities. As such, unknown payroll errors, mistakenly misclassifying an employee under a modern award or classification level, or inadvertently interpreting the payroll rules of an award incorrectly, which results in a failure to pay an employee the required amounts, will not constitute conduct which is akin to wage theft. So only in circumstances where an employer intentionally misclassifies employees or simply intentionally withholds monies will such conduct constitute a wage theft offense. So just in summary, the criminal offense does not apply for underpayments that happen because of a genuine mistake. More specifically, it does not cover honest mistakes or miscalculations. Furthermore, it does not cover a purely contractual entitlement, only statutory entitlements. So the next question would be, logically, what are the defenses? So it will be a defense to a charge of wage theft to demonstrate an honest mistake or that the underpayment was not the result of intentional conduct. Therefore, we believe demonstrating due diligence will be critical for employers relying on the defense of an honest mistake. This means that it's more important than ever for employers to genuinely seek advice, to comply with the rules and regulations under their applicable industrial instrument, so they can demonstrate that they've engaged in due diligence if an inadvertent underpayment occurs and a charge for wage theft has been laid. Another defense would be self-disclosure. So the amendments provide pathways to encourage employers to essentially self-disclose conduct, which may amount to the commission of a wage theft offense. So for example, the intentional underpayment of their workers. So this can prevent the Fair Work Ombudsman from referring the conduct to the Director of Public Prosecutions or the Australian Federal Police while the agreement is in force. So these pathways include like a voluntary small business wage compliance code and the option for the Fair Work Ombudsman to enter into a cooperation agreement with the person if the person discloses that they have engaged in conduct that may amount to the commission of the wage theft offense. So the Fair Work Ombudsman may agree not to refer the conduct for prosecution after assessing the employer against a non-exhaustive list of factors. I'll elaborate a little bit further on this, on both options, as we progress through the presentation. So in terms of penalties, the new offenses carry significant penalties, which are in addition to the rectification costs of underpayments. These include a maximum of 10 years imprisonment for individuals and a maximum fine, the greater of where the amount of the underpayment can be determined, 3 times that amount, or 1.565 million for individuals, being 5,000 penalty units, and 7.825 million for the bodies corporate, being 25,000 penalty units. So there will also be a course of conduct sentencing rule, which is based on the principles that apply to the civil contraventions. This means that if a person is found guilty of committing multiple contraventions that are part of a single course of conduct, they are treated as having committed a single contravention for sentencing purposes. For example, this is a prior case. In Fair Work Ombudsman and Hadya Nominees Proprietary Limited, the court treated multiple contraventions of the same term of an award in relation to multiple employees as a single contravention under Section 557(1) of the Fair Work Act, provided there was one course of conduct. That case was actually in 2018. However, this rule does not apply if a court has already imposed a pecuniary penalty. So pecuniary means to punish on the person for an earlier contravention of the same provision. So in such cases, subsequent contraventions are treated separately. So this approach would essentially aim to ensure that penalties are proportionate to the overall conduct rather than number of individual contraventions. In terms of commencing proceedings, I'll just give a bit of a snapshot as to what normally would happen. So proceedings for an offense against Section 327A, subsection 1 being the wage theft offense, or a related offense provision can only be commenced by the Director of Public Prosecutions or the Australian Federal Police, and may be commenced at any time within 6 years after the commission of the offense. The Voluntary Small Business Wage Compliance Code, which I referred to earlier, so the Fair Work Ombudsman published a guide or a code which helps small business employers take steps to pay their employees correctly. So small business employers who have not intentionally underpaid their employees can access the protections of the code to avoid criminal prosecution for underpayments. So essentially, it will prevent the Fair Work Ombudsman from referring a small business employer to the DPP or the AFP in relation to any possible offense against the wage theft offense, provided that the Fair Work Ombudsman is satisfied that the employer has complied with the code. So this guide is for small business employers. So a small business employer, by definition, is an employer who has 14 or less full-time, part-time, and regular and systematic casuals in total. It is not for large businesses, and large businesses, by definition, is 15 or more full-time, part-time, and regular systematic casuals in total, or independent contractors or hirers of regulated workers. Please note that the code isn't a checklist, because when you access it on the Fair Work Ombudsman website, it's not something that you could just tick and flick. This means that a small business employer doesn't need to show they meet all the factors. There's also not one factor that must be met to have complied with the code. So where an underpayment has occurred, we'll look at the overall picture, or they will look at the overall picture and the business's particular circumstances to determine whether the code has been satisfied. You can actually view the code at fairwork.gov, fairwork.gov.au/VSBWCC. As I was saying earlier, the other forms of being able to cooperate or demonstrate due diligence is a cooperation agreement. So the Fair Work Ombudsman will be able to enter into cooperation agreements in circumstances where the person has self-reported the conduct to the Fair Work Ombudsman. So this will mean that the Fair Work Ombudsman can then not refer the conduct to the Australian Federal Police or the Commonwealth Director of Public Prosecutions while the cooperation agreement is in place. So where that's located is in subdivision DE of Division 3 of Part 5.2, and it will establish a framework for the making of cooperation agreements between the Fair Work Ombudsman and a person who has self-reported the possible commission of an offense to the Fair Work Ombudsman. So a cooperation agreement is intended to provide a person with a safe harbor from prosecution. However, it should be noted that, like the code, a cooperation agreement only protects against the Fair Work Ombudsman referring a matter to the federal police or to CDPP. It does not prevent those bodies from bringing a prosecution on their own motion. So there's a new section, 717B, subsection 2, which sets out the matters to which the Fair Work Ombudsman must have regard in deciding whether to enter a cooperation agreement, including whether, in the Fair Work Ombudsman view, the person has made a voluntary, frank, and complete disclosure of the conduct and the nature and level of detail of the disclosure, whether, in the Fair Work Ombudsman view, that the person has cooperated with the Fair Work Ombudsman in relation to the conduct, Fair Work Ombudsman's assessment of the person's commitment to continued cooperation in relation to the conduct, including by way of providing the Fair Work Ombudsman with comprehensive information to enable the effectiveness of the person's actions and approach to remedying the effects of the conduct to be assessed, the nature and the gravity of the conduct, circumstances in which the conduct occurred, and the person's history of compliance with the act. So if, after having regard to those matters, the Fair Work Ombudsman decides to enter a cooperation agreement with the person, then the FERC ombudsman must not refer conduct engaged in by the person that is covered by the agreement to the CDPP or the AFP for possible criminal prosecution while that agreement is in force. So I've just given a bit of a rundown of just the legislative framework and just how the wage theft offense is applied and interpreted. I note that it's very heavy on the jargon, but of course, if you have any questions towards the end, happy to field it and we can discuss. Just moving on to the next part of the agenda. So employer obligations. Yeah, so in terms of employer obligations within the criminal code, so from a best practice perspective, employers are encouraged to comply with as many recommendations as they possibly can to demonstrate diligent remuneration. So these recommendations include, but are not limited to, so reviewing the relevant modern award, enterprise agreement, or national minimum wage order to understand what minimum pay rates, allowances, loadings, and penalties are applicable to the employee. Employers should also make reasonable efforts to stay up to date with workplace laws and obligations. So there's no one way to do this. Hence, we do encourage members to regularly review the MPAQ website for new resources and publications and access our advice line for clarification and support in understanding your obligations. This way, you can remain up to date and notified of updates to workplace instruments. Employers should also seek information and advice regarding wage entitlements from reliable sources. We have lots of information sheets addressing some common queries under the plumbing award and some further resources for the building and construction and clerks award. These documents are accessible via your Master Plumbers Association of Queensland account. To locate them, you just have to click on the dashboard, navigate to employment and wages, select wages and awards. That's where you can find our information. Other things that employers should do is proactively rectify any identified underpayments and seek to understand how they came about. By doing this, new policies, and procedures can be implemented to ensure that such a mistake does not happen again. Employers should also let me start again. So employees must receive their pay slip within 1 working day of payment. So these pay slips should clearly identify the employee's base rate of pay, any penalties applied, bonuses received, and deductions made. So why am I emphasizing this? Providing this information enhances clarity between the employer and employee regarding how their gross or net pay was calculated and is easily referenceable should any disputes regarding remuneration arise. So now let's just talk about risk management. So in terms of risks of wage theft and mitigating risks of underpayment, so non-compliance with the wage theft provisions poses numerous risks to employers, some monetary and some intangible. So as previously outlined, for a wage theft offense, a penalty of up to 10 years imprisonment and or fines up to the greater of 3 times the underpayment amount or $1,565,000 may be imposed on an individual. So for a body corporate, a fine up to the greater of 3 times the underpayment or $7,825,000 may be imposed. So underpaying staff can lead to employee dissatisfaction, as you would know, and resentment, which in turn is likely going to reduce morale, motivation, and overall productivity. It also creates tension and mistrust in the employer-employee relationship, making it harder to retain talent and foster a positive work environment. So in such a competitive industry, it's integral for businesses to promote the well-being, integrity, and security of their staff who are at the foundation of your craft. Underpayment poses a direct risk to the employee's security, integrity, and general job satisfaction, meaning they may mentally check out of the work they are performing or feel inclined to seek alternative employment. Furthermore, if a business's underpayment of staff becomes known, and it's quite common for people to talk, there is a risk that the business will be perceived as unethical and dishonest, leading to the deterioration, of their reputation. So this deterioration can deter talented individuals from applying for positions and clients from inquiring about your services because of the diminished credibility. Hence, there's a risk that present underpayments will reduce future business opportunities. So to mitigate the risks associated with underpayment, business owners should review the calculation of staff remuneration at the conclusion of each financial year when the national minimum wage is varied. The national minimum wage is varied every July of every year. So when there is an increase, we do recommend and suggest that you do actually review and audit the salaries or the rates of pay that your staff are earning to ensure compliance. By doing so, the business can confirm that the base rate of pay, penalties, allowances, and loadings paid to staff is still in full satisfaction of their entitlements under the applicable modern award, enterprise agreement, or national minimum wage order. So if there's any discrepancy that's identified, it can be promptly rectified for the commencement of the next financial year. Business owners should foster a working environment where management actively listen and therefore employees are empowered to communicate. In such circumstances, employees will essentially feel inclined to be open and transparent regarding their pay concerns or queries, which can reduce the likelihood of underpayment and the risk of staff dissatisfaction. So overall, by implementing a robust, strict payroll system that clearly details how an employee remuneration has been calculated, which industrial instrument was applied, and what associations or bodies have been contacted for information and or clarification, the business will be substantially better or in a better position should an underpayment claim be made. So with this plethora or assortment of records, the business can easily refer the employee, the Fair Work Ombudsman, the Australian Federal Police, and or the DPP to documents such as pay guides and pay slips, which demonstrate how just their remuneration of the employees was, or at least how they believed it to be. Any questions? Yeah, so the Fair Work website, I could actually type it here if you like. Just bear with me. I think I put it in my notes. Just 1 second. It'll be fairwork.gov.au, but there's a specific name for it in terms of the actual business code. Just bear with me. Sorry. Like, please don't mind me flicking through my slides. Sorry, what I'll do is I'll stop sharing my screen towards the end and I'll put it in the chat to make it a little bit easier. But yeah, sorry about that. Yeah, so were there any other questions?
Thank you, Clinton. That explained it really well. It's very, I guess, content heavy, this particular new piece of legislation. And certainly I think that we're going to see unravel a bit more as more and more claims, unfortunately, come through the Commission and also raised up from the Ombudsman. I just wanted to clarify or get your thoughts on something. So if somebody has accidentally not applied, let's say in the plumbing and fire sprinklers award, the travel allowance correctly, and they didn't apply it for all of their employees and it got recognised that they should have applied it, because it was an honest mistake from the beginning, it's not to say that each and every situation of those could potentially be an intentional wage claim, because it was an honest mistake that is a flow-on effect through the payroll system. So the employer in that scenario wouldn't necessarily be caught up in this.
Correct. So
Is that correct? Yeah.
Yeah. So an honest mistake is you pretty much summarized that correctly. It's the test is intention. So if it actually goes to the point of you look at the award and you unfortunately incorrectly interpreted it, well then that wouldn't be considered intentional because you're going off of your knowledge or understanding or the advice that you've been given that okay, this is correct. It starts to become more I guess equivalent to or arguably satisfies wage theft if you know that it's wrong and you were given advice saying like, oh yeah, this is correct, and then you decide to not do it. So that's when it presents the issue. And that's when it's definitely going to be at risk. So of course, that's why I was just saying earlier, if in the event that you do have concerns with rates of pay, it's always good to check. And we can definitely speak with you to just clarify that. Nothing wrong with double checking, triple checking. I think with the emphasis of these wage theft offenses, it just the intention or what they were wanting employers to do is just to be diligent and very much have processes along the way, if in the event that it's ever uncovered about underpayment. So now in saying that, that's easier said than done. And it will take a bit of time for a lot of businesses to, of course, some businesses to adjust, but very much so it's about having some measures in place to check if in the event that there's a I guess an error. In saying that, I actually forgot to mention one thing. The question that I've gotten before is wage theft retrospective? So if any underpayments happen prior to the 1st of January, is it captured? No, it's not. So from the 1st of January, that's when the wage theft offense is applicable. So anything prior to that isn't captured by the wage theft offense. But in saying that, that's not to say that you are subject to any underpayment claim. So of course, as you know, underpayment claims have 6 years in terms of this statute of limitations. So it doesn't mean that if an employee comes back to you saying like, hey, you've underpaid me, that yes, wage theft for that time prior to the 1st of January wouldn't be applicable, but you still have an obligation to correct that underpayment if in fact they've been underpaid. Sorry, Emma, just going off. Yeah.
No, that's great. No, you've got a very good understanding of this particular part, which is fabulous. And if I could then just jump in. So if somebody was, say, did have a claim in the past for not paying their, say, industry-specific redundancy scheme, and then elected not to because of, one, the cost, or two, the circumstances in which the employee left, whether they resigned or were terminated under the provisions of the industry-specific redundancy scheme clause. In that situation, because the employer knows about it because a wage claim has come about in the past, then that would be an intentional underpayment and that would be captured.
Yes, so that's
Yeah.
how I interpret it.
Yeah.
Yeah. So if once it becomes aware, then
Yeah.
you do have an obligation to, of course, correct that and remedy that. Yeah.
Yeah. Fabulous. And if I can ask just one more question, sorry.
Sure.
Is this particular piece of legislation only on the employer, the director, that can have the criminalisation against them, or is it other layers within the business?
Well, it's actually it's other layers. So that's a good question. So it's not just the business owners who can be prosecuted for criminal underpayment. So other people involved in an underpayment can also be held criminally responsible too. So this can include, like you said, like payroll managers or accountants in the business where their conduct. So it goes back to the general rule about intentional, right? So if payroll managers or accountants are intentionally, I guess, giving false information and saying like, yeah, look, that's you're definitely paying correctly, but they know that that's actually wrong, well, then they could be culpable, and their conduct could be interpreted as contributing to the intentional underpayment. So if you look at it just like in general terms, so it's there's a chain essentially. So like whenever you make an assessment of like pay, you may speak to someone else, and if that person is linked to that action and they intentionally give false information, well, they themselves can be culpable.
And so would, in that case, it come down to who is the responsible person that enacted the intentional underpayment? So if
Well,
it's, say, the accountant or the bookkeeper that was the one that said, no, don't worry about this payment, just pay this, and we're advising the employer wouldn't be captured by it. It would be the person who determined the intentional underpayment.
well, that's a interesting one, and that's why it will be, with the offense now in effect. Like I'm not fully across like any cases at this point in time, given how fresh it is. But in that hypothetical, it's a bit difficult to remove an employer from that scenario because they've acted on it. But again, that's why we have these defenses of like honest mistake, and self-disclosure at the point of once you've uncovered it, you try to correct it. It's a tricky one because of just the overlapping kind of parts to that situation. I think where it becomes more along the lines of the possibility of wage theft is if it can be demonstrated that the employer became aware that it's wrong and then continued to pay it incorrectly, well then yes, I think that would be more likely that it's wage theft. I think if they went along with it, then tends to align with the idea of an honest mistake because you're being advised. So it's kind of time and place in terms of identifying it. Which of course that's the risk involved, and like I'm very interested to see how it works in terms of like upcoming cases. But yeah, like on a general note, people who have been involved in the I guess, or contributed to the intentional underpayment can also be caught in the offense.
Yeah, fabulous. Thank you.
Oh, that's a good question. Can I ask what percentage of trade businesses do you think are unaware of the redundancy specific payment scheme? Q leave. I'm not really I'm not the best with stats, but I think like generally from my conversations with a lot of members, it's I think most members have an idea, and I think that it's a good thing that we have those resources online, because we do have a bunch of information sheets which touch on like overtime and allowances as well as the specific redundancy payment scheme. But I can hand it to you, Emma, if you want to address that question. Or
Yeah, I guess we don't necessarily have the complete stats on what our membership would look like in terms of having a knowledge of it. I guess because of, yeah, we've certainly got a lot of information on our website regarding it. It can come down to the nuances of the situation when the employment ends, as to whether it's paid or not paid. And so then that in that circumstance, there's always the ability to call through to our advice line. I think it's becoming more and more well known by employers now, particularly when an employee resigns and they've fulfilled that 12-month period, they do get that payment. And so we certainly keep our members informed through our MPAQ update as well, so keeping an eye out in our newsletter. In terms of Q leave, yes, I think majority of members know to make sure to register their employees for Q leave, certainly when they start, and then when they end, use that as part of their, I guess, termination process of who to contact to make sure that that employee has ceased with that business for Q leave payment.
And sorry, just to confirm, so Q leave is essentially portable long service leave pay. So that's not captured by wage theft. So those are one of the exceptions. So payments in relation to long service leave or superannuation, or like contractual payments that are higher than the minimum rates of pay that would be covered by like the modern award or legislation or the Fair Work Act. That is separate. So that wouldn't be captured by the wage theft offenses. But in saying that, it could raise other risk in terms of failing to pay long service leave under a different authority, in terms of like the portable long service leave authority. So it's the wage theft provisions are very specific to when, just to generally just kind of succinctly put it, the modern award, or like entitlements that you would normally think about in terms of minimum rates of pay under the Fair Work Act. So things like superannuation, long service leave, that's not covered by wage theft, but of course failure to pay that would be subject to possible risk in terms of other authorities, like the portable long service leave authority. Any other questions?
Certainly, if anybody thinks of a question afterwards, feel free to call through, because we want to get everybody to have a good understanding of this, because I guess, as Clinton has highlighted, the penalties are very high, the risk to the business is quite significant, and obviously that overarching criminalisation of it, you can go to jail.
Lots of information to take in. Yeah, I'll give everyone a few more minutes just to see if anyone else has any other questions or anything else that they want to add or raise. As we said earlier, we have recorded this webinar, so if you do want to rewatch it, then you will be able to do so shortly on our website. Otherwise, as Emma and Clinton said, you can reach out to the MPAQ advisory team just by calling our number, the 3273 0800, if you want to understand more. Doesn't look like any other questions are coming back in, so I'll say thank you, Clinton, for sharing your knowledge on this important topic.
Thank you.
And thank you to Emma for helping to organise the webinar today. Thank you to all of you for joining us, and just for your information, we do have a whole host of online and in-person events and training courses coming up this year, including workshops on maximising profitability, practical AI solutions, all kinds of weird and wonderful topics. So make sure to check out mpaq.com.au/events to find out all the upcoming details. But otherwise, I hope everyone enjoys the rest of the day, and let us know if there's anything else we can help you with.
Thank you, Emma.
Thank
Thank
you.
Thank you,
you.
everyone. Speak soon. Bye.